Further, in an election petition, the election court has no jurisdiction to determine a criminal matter or whether an offence under the Election Offences Act was or has in fact been committed, since that is an issue squarely within the jurisdiction of a special magistrates court. Such court must be specially constituted by the Chief Justice under Section 23(1) of the Election Offences Act, which provides as follows. The Chief Justice may, by notification in the Gazette, appoint as many special magistrates as may be necessary to hear and determine matters relating to offences under this Act. In light of the foregoing, this court as an election court can make a determination only on whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Elections Act, but not on whether the offence of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. Ultimately, however, the question I must answer on this issue is whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election. From the evidence above, I am unable to find that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. We are talking about two witnesses who said they were bribed. And I only accept their evidence because it was not controverted by the respondents. Issue number 6. Whether there was a broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling. The petitioner made claims of a wide range under this issue, alleging broken chain of custody and unlawful handling of election materials. However, he was not an eyewitness in any of these events, neither was his chief agent, that is PW2. The main evidence that emerged in respect of this issue was that concerning Itiburi Primary School Polling Station 2, where there was a fire, and Kaungu Polling Station, where there was an invasion by unauthorized people. PW6 Dan Degwa, the party agent for Safina Party, stated that he was at Kitiburi 2 when a lamp fell and triggered a fire in the classroom that was set up as a polling station. He said that they rushed out and then he rushed back into the room to retrieve his phone, which was charging there as he helped put out the fire. He stated that CS Rocco came to the station with about 300 people in tow, and they occupied the classroom. Were placed inside the Nissan van, which was left unguarded outside, and he believed that they could have been interfered with. He said that by that time he had been handcuffed on the instructions of CS Rocco, and some agents had run away. In his affidavit, PW6 could not confirm what happened at the voting in the classroom as he was seated at the back observing. In his oral evidence, he reconfirmed that it was about 5 p.m. when the fire broke out, as the PO was attempting to light the gas lamp, or a gas lamp. That bedlam then broke loose, and the crowd of people started coming into the polling station. A video named NNK23 Collection Gitiburi was shown. He said that the crowd comprised of about 300 people, and at the time the ballot boxes were still in the classroom where they were left when the fire broke out. He further stated that locals salvaged the ballot boxes and took them to the vehicle, that the PO and DPO were not in the vehicle when the ballot boxes were taken to it. IEBC officers were called to come and collect the boxes from the vehicle, and they complied and picked the boxes. On further cross-examination, PW6 stated that there were things taken outside the polling station classroom by strangers. He said that he did not see in the video the ballot boxes being carried out by locals to the vehicle. Upon viewing the aforesaid videos, the court noted that as follows: there indeed was a fire, that there was commotion at Gitiburi, that there was involvement of large crowds of people, some armed with sticks, that there was also a van into which some IEBC officials in IEBC reflective vests were seen attempting to enter. However, no ballot boxes were seen in the videos. Hence, the videos do not support the allegation of third parties handling, I'm talking about handling, the ballot boxes. In his affidavit, PW7, Simon Kariuki, a voter at Gitiburi, stated that shortly after the fire was controlled, CS Roko came to the station accompanied by people armed with sticks and rungus, and they took the ballot box to the vehicle whilst beating people. That CS Roko demanded that the ballot boxes be brought to one classroom and ordered that the ballots from both Gitiburi 1 and 2 polling stations be counted together. One of the ballot boxes emerged from amidst the crowd and was given to CS Roko, who gave it to IEBC officials. That CS Roko demanded that the votes, that the votes be counted and tallied. He did not witness reopening of the ballot boxes again, and he denied signing forms 35A. He stated that the counting took place in one polling station at Gitiburi. RW4 Jane Karim Induma was a presiding officer at Gitiburi 1. It was her evidence through her affidavit that after the polling ended at 5 p.m., she secured the room before counting started. She confirmed that CS Roko came to the station and caused commotion. She noted that there was a fire at Gitiburi 2, that she prepared the polling station as a counting room. She made no mention of Gitiburi 2 in her affidavit. In her oral evidence, RW4 testified that there was a fire at Gitiburi 2. It led to a commotion because there was a large crowd of people. She took the ballot box and took cover in a vehicle. That vote counting started at 7 p.m., that the votes for Gitiburi 2 were also counted at Gitiburi 1. In cross-examination, she stated that she did not see CS Roko and that he was not involved. She admitted that she hosted another polling station and that no one authorized her to do so. When shown a video of the fire incident at Gitiburi, RW4 confirmed the incident was as depicted in the video. She saw the PO of Gitiburi 2 in the video with people in the crowd holding sticks at the scene. By that time, she said she had secured the ballot box in the vehicle. She said no polling officer for Gitiburi 2 was in the vehicle, but the boxes for Gitiburi 2 were there. On re-examination, her evidence was that after getting to the vehicle with her ballot box and with the security officer, she realized that she had left some personal items in the polling station. She thus left the ballot box in the vehicle to get those items. That was the only time she left the ballot box unattended. RW3 Lydia Kamau was the PO for Gitiburi 2. In her affidavit, she stated that after closing the station, she closed the KIMS and sealed the aperture at 5 p.m. She then called for a short break before counting began. At around 5:30, her deputy, Felix Mwaniki, lit a gas lamp which burst into flames. She managed to secure the ballot boxes. She telephoned Siakago police station and reported the incident and was issued with an OB number such and such. She stated that CS Roko came to the station and that his arrival caused some commotion. RW3 further stated in her affidavit that during the brief incident of the gas lamp explosion, the election materials remained secure. Let me read that again. RW3 stated that when the fire broke out, she took the boxes to the vehicle hired by IEBC together with the security officers and agents. She said that she and her team transferred their materials to Gitiburi 1 to count ballots, and they found Station 1 already going ahead with counting. In further cross-examination by Mr. Ndegwa, she stated that the forms which were burnt were KIMS Forms 32A. From the DR scrutiny report of 17th April 2026, the DR noted that the PSD for Gitiburi 1 recorded the fire incident as follows. Incidents recorded on page 30 as an accidental fire in Station 2 at 17:30 hours. Fire was put out and calm restored. Security backup. In Gitiburi 2, the PSD indicated that the PO recorded gas cylinder exploded and some of the forms were burnt. We were able to secure the ballot papers, ballot boxes, KIMs, and some forms. It is clear from the totality of evidence adduced that in Gitiburi 1 and 2, polling had concluded by the time the disruption arose from the fire and the crowd that invaded the polling stations. That RW4 took cover from the crowd in the vehicle and at that time the boxes from Gitiburi 2 were in the same van without any officer from the polling station. It was admitted by RW4 that at some point she also left the box for Gitiburi 1 in the van unattended when she left to get her bags which had been left inside the polling station. With regard to evidence on Kaungu, RW7, Paulino Nthiga Njeru, the PO, stated that he witnessed violence from a distance outside the polling station, including stones thrown into the polling station. He then stopped the election process for 30 minutes. When he reopened, voting continued, but the voter turnout was lower than earlier. He recorded in the PSD that locals and some politicians disrupted the polling process when some windows for the polling station were broken. Voting was disrupted between 13:45 and 14:15 hours, and action taken was the aperture was sealed at 13:45. All election material and officials were put under tight security. Thus, for Kaungu, it was the actual polling that was interrupted at 1:45 p.m. and the polling station was closed for 30 minutes. However, there is no evidence that during this time the election materials were removed from the polling station or were outside the PO's control. In summary, the evidence on this issue, we are looking at the issue whether there was broken chain of custody and lawful handling of election materials and violation of procedure of close of polling. In summary, the evidence on this issue is as follows. 1, at Kaungu, despite the fact of disruption of polling, the election materials were not interfered with. 2, at Gitiburi 1, the disruption occurred after closure of the polling station at 17:30 hours as recorded in the PSD. At Gitiburi 2, the disruption occurred after close of the polling station according to the PO. Number 4, at Gitiburi 1, the evidence is that the election materials were left unattended in the van according to the PO. 5, the evidence concerning the election materials at Gitiburi 2 is inconsistent, namely that they were handled by unauthorized persons and also that they were left unsecured or unattended in the van or that they were secured. It is not clear. The evidence is inconsistent. From the DR's supplementary report dated 22nd April 2026, the results in Gitiburi 1 as recorded in the PSD, Form 35 and KIMS were consistent, save for one ballot paper marked in favor of the fourth respondent with no corresponding counterfoil. For Gitiburi 2, the report shows that the KIMS kit showed that the last voter was verified at 16:55 hours, while the PSD indicated that the polling was closed at 1700 hours. There was one ballot cast in favor of the fourth respondent, but no corresponding counterfoil for it. The totality of the above evidence discloses that for Gitiburi 1 and 2, there was broken chain of custody, possible and lawful handling of voting material, but no violation of poll closing procedure. For Kaungu, there was no evidence of broken chain of custody, unlawful handling of or violation of poll closing procedure. Consequently, there is no basis for finding that the irregularity or non-compliance was substantial and that it affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread and occurred during the polling, a positive case would have been made to conclude that the violence affected the overall quality of the election and had a significant effect on the result. Issue number 7, whether there was use of state resources, state security and public office to influence voters which constituted abuse of power and improper influence in violation of Articles 10, 73, 75 and 81E of the Constitution under the Elections Act. The petitioner's complaint of the use of state resources, state security and public office to influence voters was, from an evidential standpoint, entirely contained in allegations. I have carefully perused all the evidence that was adduced with a view to identify concrete evidence concerning the use of state resources, state security and public office to influence voters. I have not found any. What I find in this case is that there is evidence that CS Roko, together with Embu governor and other public officers, were mentioned by witnesses as intimately involved in the campaigns leading to election day. It is probable, but not proved, that these officers were using state vehicles or state resources for transportation during the election period. They may also have used state resources such as police personnel. There is clear evidence that enhanced police presence was noted by many witnesses. That is also clear from the videos played in court, where in some cases, vehicles with no number plates were seen. It is also likely that by virtue of the power, stature, and influence of their public offices, these officers could readily command attention of or influence voters. No evidence, however, has been adduced concerning actual abuse of office and improper influence by any particular state or public officer. It was incumbent upon the petitioner, in order to prove issue 7, to provide at least the following evidence: names of the public officers, this they did, a number of them, their designations and offices held, and particulars and nature of the alleged abuses of such offices, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced, and accordingly, I am unable to find in his favor on this issue. Issue number 8, whether there was delay in counting votes, exclusion of agents, defective and falsified statutory forms, opaque counting and tallying in violation of Article 86 of the Constitution and Regulation 79 of the Elections General Regulations. With regard to delay in counting votes, the only evidence presented related to Gitiburi 1 and 2 were the breakout of the fire affected the timely counting of votes. Regarding exclusion of agents, the only evidence was that of PW6, who alleged that he was handcuffed and detained in a police vehicle until 8 p.m., hence was denied a chance to witness counting of the votes. From the DR scrutiny reports, agents of the petitioner were present in the stations where scrutiny was ordered, and they signed Forms 35A. With regard to defective and falsified statutory forms and opaque counting and tallying, the allegations in the petition were that Forms 35 were overwritten, resulting in opacity of results. In respect of Kerie Polling Station 2, Nazario Mugo, who was the PO, did not testify on the inconsistencies between Forms 35A and 35B, showing a total number of votes obtained and cast as 225 and 223 respectively, a difference of 2 votes. I looked at the form carefully, the Forms 35. The tally on the right-hand side for each candidate is indicated as in a total. That figure is supposed to be translocated to the column on the left-hand side, and the 2 should tally. So the key figure that is of interest is the one on the right-hand side, not the translocated figure. In respect of Gitiburi 2, RW3 Lydia Kamau, the PO, did not testify on the inconsistencies between Forms 35A and 35B, which indicated that the number of valid votes obtained and cast is 261 and 262 respectively. However, during scrutiny, the votes were recounted and the number of valid votes cast remained 262, meaning that Forms 35B was erroneous by 1 vote. In respect of Mushonoke 2, Timothy Nyaga Maringa, the PO did not testify on inconsistencies between Forms 35A and 35B, showing 304 and 303 votes respectively on the number of valid votes obtained and cast. Scrutiny was not done for this station, and the inconsistency of 1 vote remains unexplained. At Kamugo Polling Station 2, Form 35A indicates the number of valid votes obtained as 449, which is where the tally for each candidate is indicated. Whereas in the section of polling station counts, at item 5, the total number of valid votes cast is indicated as 456. This is on the left side of the form, 35. And the total rejected votes are indicated as 7. Shadrach and Nyaga and Jagib, the PO at this polling station, did not testify, and no further explanations were made regarding this inconsistency of 449 and 456 votes. On this latter inconsistency, it appears likely to the court that the 7 votes difference is attributable to the total rejected votes being carried to item 5 and added to the votes obtained. These unexplained inconsistencies in these votes, all these Forms 35 that I've referred to, these unexplained inconsistencies, I should say, add up to 10 votes in Forms 35. Add up to 10 votes in Forms 35A, a difference of 10 votes in Forms 35A and 35B, so that the election result has a 10-vote difference, unknown as to whom those votes would benefit. The scrutiny did not find anything to suggest any irregularity, but rather careless mistake in translocation from the vote tally column of Form 35. 35A, Form 35A. Regarding allegations that some 37 Forms 35A were overwritten and not countersigned, the court allowed scrutiny of only 8 of them where such overwriting demanded scrutiny. The DR's scrutiny report, dated 17th April 2026 at pages 21 to 24, found that despite overwriting, the figures added up to the total valid votes as in Form 35A. There was no major discrepancy noted. The court agrees that the overwriting did not result in any discrepancy, and the irregularities cannot be said to substantially have affected the will of the people. The will of the voters, not the people. The petitioner also complained during the hearing about errors on Forms 32 in respect of assisted voters. I have had to deal with this issue because it arose during evidence repeatedly. At the outset, it is essential to note that the issue of assisted voters was not pleaded, either in the petition, in the petitioner's issues, or in the grounds of relief. It featured, however, in the supporting affidavit of the petitioner. In one paragraph, we'll get there, and in some of the other affidavits of the petitioner's witnesses, and also in witness testimony. In paragraph 94 of the supporting affidavit to the petitioner deposed as follows: that further, the said agents would bribe the voters on condition that they declared that they were illiterate and in need of assisted voting. This led to exhaustion of oaths of secrecy forms due to inexplicable influx of persons allegedly in need of assisted voting. The second respondents filed an affidavit in support of the response to the petition. The first to third respondents did not respond specifically to the allegation made under paragraph 94 of the supporting affidavit of the petition, even though on their behalf the second respondent acknowledged as follows: that I have read and been explained to by Charles Benedict Mongela, counsel on record for the first, second and third respondents, the election petition dated 22nd December 2025 and the affidavit in support of the election petition sworn on 22nd December 2025 by Ndwiga Newton Kariuki, and wish to respond as follows. So the issue became sort of subsumed through the affidavits. In furtherance of his claims on assisted voting, the petitioner during his testimony on numerous occasions reiterated his claim on bribery and assisted voting, which featured in his supporting affidavit. Other witnesses of the petitioner, for example PW10 and PW11, considered that as they were accepting bribes, others in the group and in the premises at the house of Edward Njage, where they were also accepting bribes to become assisted voters. PW9 Julieta Kidhumbu testified that she saw many assisted voters at Muchonoke Health Center 2 polling station, where she was the agent. She said that there were mobilizers who brought assisted voters to the station. In one case, she saw an assister assist 4 voters. And she complained to the PO, but did not record the fact in her notebook, though she signed Form 35A without objection. The issue of assisted voters became pronounced after the court ordered that election materials be preserved into the custody of the court and the DR to make a detailed report on the movement. That's the movement of the materials. The record of that movement of materials for preservation is contained in the DR's report pursuant to the directions of the court dated 15th January 2026 for removal of the election materials from IEBC to Embu High Court. The report is dated 27th January 2026. In it, the DR recorded having received the following boxes from a strong room of IEBC offices in Embu. 134 ballot boxes, namely 1 from each polling station. 1 box captured as the 135th ballot box delivered at the tallying center. 4 boxes recorded in an, quote, inventory of other strategic materials issued to Embu High Court for the Mbere North by-election petition, unquote. And finally, 15 boxes containing Kim's kits. Of the 4 boxes in the inventory of other strategic materials issued to Embu High Court for the Mbere North by-election petition, that was box number 114337, it contained, amongst other things, 1,072 Forms 32, declaration of secrecy, made by a person assisting a voter. Naturally, this inventory raised concerns as to why these materials were produced from the IEBC offices at Embu without any record by the returning officer. Accordingly, in its ruling, paragraph 62 and 4, 62.2 and 4, delivered on 27th March 2026, the court ordered scrutiny of other strategic materials issued to Embu High Court. Following scrutiny by the DR, she reported her findings at page 15 to 19 of her report of 17th April 2026 as follows: that there were 1072 Forms 32, folio marked 1 to 1072. Out of these, 10 were blank or unpopulated in any way, blank forms. There were forms by 6 declarants which had filled forms, not which, by 6 declarants who had filled forms twice, of whom 2 declarants filled 2 forms at 2 different polling stations, while the other 4 declarants each filled 2 forms at one station. That is all contained in Table 4 of that report. RW1 testified that at the tallying center, he received 134 ballot boxes. He also stated that he handed over to the DR 135 ballot boxes with 1 box containing strategic materials. He stated that he prepared box 135 out of good faith. He gave no explanation for any of the other boxes. According to the IEBC polling station diary template, forms 32 from each polling station where voters were assisted were required to be put in a tamper-proof envelope and handed over to the returning officer. However, during scrutiny, all forms 32 were found unsealed and loosely filed in a box file in box number 114337. The foregoing handling of Forms 32 shows a rather casual approach to a very important act of verification and secrecy relating to assisted voters in exercise of their right to vote. Added to that casualness, there was the neglect and failure to record the same in the register. Indeed, there was no way of accounting for these forms, for example, either in the polling station diary or in the voters' register. The stipulation of the law on aided voters is found at Regulation 72(6) of the Elections General Regulations, which provides as follows: where a presiding officer grants the request of a voter under this regulation, the presiding officer shall record in the polling station register against the name of the voter the fact that the voter was assisted and the reason for the assistance. It was not contested that the physical voters register that was deployed was contained in a sealed tamper-proof envelope, and that it was never physically opened, but was only used to open the KIMS kit through the QR code. What requires interrogation is whether an election court may assess or make determination on irregularities or illegalities revealed during scrutiny or recount where such matters were not specifically pleaded. My understanding is that what is required is a continuous balancing between 2 competing constitutional and procedural imperatives. On the one hand is the cardinal rule on adversarial litigation, that parties are bound by their pleadings, ensuring procedural fairness, certainty of issues, and protection against trial by ambush. On the other hand, there is the constitutional duty imposed on election courts to safeguard the integrity, verifiability, accountability, and transparency of elections under Articles 86 and 81 of the Constitution. It is a substantive rule of adjudication that pleadings have a binding force. In IEBC versus Stephen Mutinda Mule and others, the Court of Appeal stated in unequivocal terms that parties are bound by their pleadings and that evidence which departs from the pleaded issues goes to no issue and must be disregarded. The same logic was reiterated in Raila Odinga and 5 others, Supreme Court Petition number 5 of 2013. There, the Supreme Court emphasized that parties are bound by their pleadings and evidence must be confined to pleaded issues. Similarly, the Supreme Court in Zachariah Okoth-Obado and Edward Oyugi, Supreme Court Petition 37 of 2014, reinforced the position that election petitions are strictly framed disputes. Respondents are entitled to know with precision the case they must meet, and the court is equally constrained by the issues framed in the pleadings. This establishes pleadings as the primary jurisdictional boundary of electoral adjudication. Against this strict framework, the Supreme Court in Gatirao Peter Munya versus Dixon Mwenda 2014 set out the governing logic on scrutiny, which is that scrutiny is not a fishing expedition. It is a verification mechanism tethered to pleaded allegations. The court was clear that scrutiny cannot be used to discover new causes of action or to sustain a petition that fails on its pleaded grounds. However, the court also recognized a controlled opening, namely that where scrutiny is properly ordered, particularly by the court itself, as in this case, what emerges may be interrogated by the parties and evaluated for its impact on the integrity of the result. Can courts therefore ignore serious electoral irregularities that emerge from scrutiny? Where scrutiny is triggered by a party's application, its scope is strictly confined to the pleaded issues and the specific polling stations in dispute. It cannot be used to enlarge the petition or introduce new grounds of challenge. Yes, several cases cited. By contrast, where scrutiny is ordered suo motu, which is I think what this court did, the court may direct scrutiny as part of its case management powers to clarify the evidentiary record, but this does not expand the issues for determination or convert scrutiny into an inquisitorial process. Any irregularities emerging from the scrutiny remain subject to contestation by the parties and must be evaluated within the pleaded issues and the constitutional standard of electoral compliance. The question whether the court should turn a blind eye on malpractices arising from scrutiny was focused on in the Musikari Combo case, 2014, where the court held that an election cannot turn a blind eye to serious electoral malpractices revealed during scrutiny or recounts simply because they were not pleaded. The court justified this exception on constitutional grounds that electoral justice cannot be reduced to procedural technicalities where the process itself is shown to be fundamentally compromised. In Peter Kingara versus IABC 2014, the Court of Appeal emphasized that scrutiny is not an avenue for building a new case. That position was reaffirmed in many other cases, and I've cited a number of them. The courts have reiterated that scrutiny must remain tethered to pleaded issues unless exceptional procedural safeguards exist. That caution was emphasized also in Walter Nyambati case, 2018, where the Supreme Court stated that scrutiny is not a fishing expedition, cannot be used to latch onto whatever evidence to construct a case not pleaded. I've cited Abdikadir Hussein's case, the 2023 High Court. Kenya Court of Appeal, where the Court of Appeal introduces a decisive procedural safeguard that even where serious irregularities are revealed by scrutiny, an election court cannot rely on them without first placing the adverse party on notice and affording an opportunity to respond. The court treated this not as a discretionary courtesy but as a requirement of due process, and pleaded material cannot silently or automatically mature into grounds for nullification. In the present case, and as already pointed out, the issue of assisted voters featured significantly in the petitioner's supporting affidavit and upon hearing of the evidence of the petitioner's witnesses. The respondents thus had a full opportunity to deal with the issue. It was evident as far back as was recorded in the DR's report on movement of the preservation materials and in the petitioner's witness affidavits. There was no ambush, in my view. In its decision in Kombe versus Karisa and three others, 2024, Kenya Supreme Court, the Supreme Court affirmed the core principles in Munya on scrutiny. The Apex Court stated as follows at paragraph 107, the Court of Appeal relied on the decision of the Supreme Court in Munya that scrutiny is a vehicle to assist the court to verify the allegations made by the parties to the petition, which allegations themselves must be hinged on pleadings, that it was never intended to enable the court to unearth new evidence on the basis of which the petition could be sustained. From the record, the Supreme Court accepted that the trial court had engaged extensively with scrutiny findings such as unstamped counterfoils, polling station inconsistencies, and irregularities in statutory forms. The Court of Appeal had criticized reliance on some of these matters as unpleaded. The Supreme Court's reaction was not to abandon the pleadings rule, but to recharacterize the function of scrutiny evidence within the broader evidentiary inquiry. It held in substance that scrutiny findings do not operate as stand-alone causes of action, but neither are they legally inert simply because they were not expressly and specifically pleaded. At para 108, the Supreme Court noted as follows, it would appear therefore that the report of scrutiny did not yield the outcome expected by the first respondent when he sought it. That did not preclude him from presenting and relying on other pieces of evidence to illustrate that the election in question did not conform with the constitutional and legal imperatives. In the present case, the question of assisted voters was not specifically pleaded, as already stated. Nevertheless, it does not arise entirely as an ambush. Since the petitioners supporting affidavit and the first to third respondents replying affidavits took notice of the issue. When the court ordered scrutiny of the assisted voter forms, this emanated from the fact that they were produced for preservation without any record as to how they found their way into the box and files. They were delivered in. The court was thus entitled to order scrutiny thereof, since oral evidence had been taken and no proper account of the Forms 32 had been given by the respondents. Thus, scrutiny was duly ordered and forms part of the evidential matrix. In my view, the outcome of the scrutiny may be used in evaluation of whether the totality of the electoral process met the constitutional threshold of integrity, verifiability, and accountability. The decisive question is not whether each irregularity was individually pleaded, but whether the election, taken as a whole, complied with the constitutional and statutory standards. The authorities hold as follows, and I have cited Mohammed Abdi. Let me read it. Where the Supreme Court majority refined the remedial approach to Regulation 72, non-compliance, by requiring that such breaches be assessed within the broader Article 86 framework of verifiability and materiality, rather than be treated as automatically determinative of electoral invalidity. Where in the first instance the failure to mark the register is isolated or inadequately proved, the courts generally decline to nullify elections, although the failure weakens the credibility of the official account. This was the position in Mohammed Mahmoud Ali versus IEBC, Mombasa High Court 2017. Further, if the failure becomes systemic, particularly in constituencies where assisted voting would predictably be widespread, courts may infer that the process itself became unverifiable. In light of the foregoing analysis of the law, this court can now make the following conclusions. First, that Regulation 72(6) of the Elections General Regulations was violated in respect of the 1072 assisted voters, as they were not recorded in the physical register as required, nor was there evidence that they were indicated as such in the KIMS register or PSD. Secondly, that the only evidence available that there were assisted voters is the existence of Form 32, which is the declaration of secrecy, in compliance with Regulation 72(5), indicating the declaration of secrecy by persons that assisted the said voters. Thirdly, with regard to double declarations by the 6 declarants earlier discussed as found during scrutiny, these were in breach of Regulation 72(5) of the Elections General Regulations, which provides that as follows: the following shall apply with respect to a person who assists a voter under this regulation. The person shall assist or support only one voter at that election and have a mark as proof of assisting or supporting a voter. Fourthly, while the court take the position that all assisted voters' votes be struck off, it would not change the result of the election, as it is impossible to identify for which candidate they voted. Finally, taking into account the caution of the superior courts concerning unpleaded issues and considering these violations cumulatively with the other irregularities pleaded and on which evidence was availed and has been evaluated, I am not satisfied that it was ultimately shown that the results did not reflect the will of the people in relation to assisted voters. Conclusions and disposition. On issue 1, the court found that the evidence of the petitioner did not list the IEBC officers in issue, did not identify which of the officers were opaquely. Actually, I've just reiterated, I've plucked from the body of each conclusion, I have brought it back to the conclusions and disposition. So that on issue 1, I find that no qualitative disqualifying attribute in appointment and dismissal of IEBC election officials was demonstrated. On issue 2, again, I have plucked the conclusion I reached under that issue and brought it forward. It was demonstrated by evidence that there was a physical register, voters register available at every polling station, that it had a QR code, that the KIMS kit had a soft copy replica of that register. No evidence was availed that any voter was disenfranchised, since the physical registers were present and were also replicated in the KIMS kit. Then I point out the jurisprudence on the use of the physical register is essentially what is carried in the UDA case, that such register is only to be used in instances where biometric or alphanumeric identification fails. The UDA case, I may say, does not entirely deal with Section 72, Regulation 72. It doesn't entirely with regard to assisted voters. There was no evidence of such failure of identification. The prevailing jurisprudence on the use of registers is the UDA case, is that such register is only to be used in instances where biometric or alphanumeric identification fails. There was no evidence of such failure of identification. Had there been a failure of biometric and alphanumeric identification, followed by failure by IEBC to deploy the physical register, a case of voter disenfranchisement would have been readily made out. On issue 3, whether there was unlawful third-party interference, on this I came to the conclusion that it was not proved that admitted interference with the register was either widespread, systemic, or intended. In substance, therefore, there was no proof that of the fact that the sole instance of interference that we saw in the case of Collins affected the will of the people. It was also held that in the case of one individual, where the register was shown to have been unlawfully altered, the officer involved may have committed a criminal offense. On issue 4, the same summary that I take the same summary or conclusion, and this is where I said Kaungu theoretically suffered a turnout decrease of about 8% or 51 voters as against the constituency average. But I found overall the failure did not affect the outcome in terms of Section 81 of the Elections Act. Section 82, sorry, of the Elections Act. On issue 5, whether there was bribery treating, maybe I just read all of them, if you don't mind. Let me just read all of them so that I don't give an impression. On issue 5, whether there was bribery, treating, and undue influence in violation of the Election Offences Act and the Constitution, there was uncontroverted evidence of bribery involving 2 witnesses. As an election court, this court can make a determination only on whether the election malpractice, whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Election Act, but not on whether the offence of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. As to whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election, the evidence does not show that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. On issue 6, whether there was broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling, the totality of the evidence availed disclosed that out of 134 polling stations, there was broken chain of custody, possible unlawful handling of voting material, but no violation of poll closing procedure at Gitiburi 1 and 2, except with regard to the time. For Kaungu, there was evidence of violence, but no evidence of broken chain of custody. unlawful handling or violation of poll station closing procedure. Consequently, there is no basis for the finding that the irregularities or non-compliance were substantial and affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread, a positive case would have been made out to conclude that the violence affected the overall quality of the election and had a significant impact on the result. Issue 7, on whether there was use of state resources, state security offices to influence the voters. It was incumbent on the petitioner, in order to prove issue 7, to provide at least the minimum information or proof, the names, some of which were provided, their formal designations, the offices held, and particulars and nature of the alleged abuses of such offices, provisions of the law breached, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced. Accordingly, the court is unable to find in his favor on this issue. On issue number 8, the court was unable to find in favor of the petitioner, the same on even the assisted voters. Because with the assisted voters, what I have done is that I have said I take seriously the caution by the superior courts concerning unpleaded evidence gathered through scrutiny. The outright determination, the overall determination, for all the foregoing reasons, the court finds that the petition was not proved to the required standard, and it is hereby dismissed with costs. The costs are as follows. The parties made submissions on costs, generally to the effect that costs follow the event. The first to third respondents' counsel went into some fair detail in indicating the depth of the case, the number of attendances, preparatory time, complexity, and so on. The first to the third respondents and the fourth respondents both indicated that costs should be at Kenya shillings 5 million. The petitioner only submitted during highlighting. So having considered the nature of the case and the input of the parties and noting the fourth respondent did not testify to or avail witnesses, I hereby cap party and party costs at Kenya shillings 4 million. The first to third respondents shall be entitled to 70% thereof, and the fourth respondent to 30% thereof. I have prepared a report of the court on electoral malpractices under Section 87 of the Elections Act, which is as follows. The court finds that the following malpractices of a criminal nature may have been committed. And directs that the same be transmitted to the DPP. A. Admitted alteration of register without authority, contrary to Section 6(1) of the Election Offences Act. B. Double assistance of voters, that is allowing 6 persons to assist more than one voter, each contrary to Regulation 72(5)(c) of the regulations. C. Failure to record in the polling station register against the name of the voter the fact that the voter was assisted, contrary to Regulation 72(6). I will make recommendations separately. I will not, because there's no point of putting the recommendations in the judgment, but I'll make recommendations separately, particularly for IEBC's notice, subsequent to this judgment, because I think it is important. Certificate of court as to validity of the election under Section 86 of the Elections Act. Having concluded the hearing of the election petition, I certify that the petition was dismissed and the fourth respondent remains the duly elected member of parliament for Mbeere North constituency. This information is to be transmitted to the Speaker of the National Assembly. Orders accordingly.
Yeah, my lord, we are most obliged by the decision of the court. We have sat and listened to it. We appreciate where the court is coming from, but we, however, would wish to make an appeal in regard to some of the issues the court has dealt with, and therefore, my lord, we are making an application for expedited provision of typed proceedings, the judgment of the court, and the decree accruing therefrom. Your Lordship, the reason for the appeal is, my lord, that this might be the only time the certain issues will be clarified by the Court of Appeal, most importantly the question of the alteration of the voters register. And my lord, since I am not making an appeal before you, would wish to make the Court of Appeal pronounce itself. Number two, your Lordship, on the question of the scrutiny that was dealt with by the Deputy Registrar. Lord, we have listened to you and the judgment, and we note that the judgment itself does not capture the entire report as reported by the Deputy Registrar, and most importantly, in respect to ballot box number 35 and the 212 votes that were cast in foil. We have not heard you pronounce yourself on that, your Lordship. Would we therefore wish to make an appeal? And then, my lord, I don't know how that will square out, because it has not been captioned in your judgment. Because, my lord, when you ordered,
it should be easy enough, because the proceedings of the registrar will be part of the proceedings of the
yes,
court.
my lord.
So you just annex them and say that the lower court failed to deal with an issue.
My lord, we will be obliged. We are otherwise happy that the court has made its decision. We'll try our luck in the Court of Appeal. We are most obliged.
Fortunately, the judgment is typed already.
Yes, my lord.
The proceedings are typed, so it should be fairly easy to get the record fairly quickly.
We will get it now.
Yes,
my lord, Kirago Aduta, and I thank you for that judgment. My lord, I just have one request, and as we review the judgment, so that then we can see what we make of it in terms of what is the next step, we just like to make an application for stay of execution on the issue of costs, because we know we have money in court. Yeah, so that, my lord, the issue of costs may be given about 30 days for us to review the judgment before the money is released, if such an order is sought, so that then we can make the appropriate application, if any, upon taking instructions. So that, my lord, if, as Mr. Ndegwajiro mentioned, if there is any need for review or clarification from the court, then we can have that period to consider all those options. That's all, my lord. Yeah, I'm being informed that I seek 45 days, kindly, my lord. 45 days, my lord. That's all, my lord. Thank you.
He's asking for 45.
Yes, I hear you, my lord.
Yes.
We would be opposing the request for stay, my lord. There is no indication upon which such a stay would be predicated, my lord. No appeal has been filed as yet. Even the costs have not even been ascertained. My lord, on the second issue, the IBC takes note of the issues you have raised, and they welcome the report which will be extracting and sending them from this judgment, my Lord, which is going to inform the improvement, the improvement in terms of how they conduct their affairs and how the elections can be improved better. Otherwise, my Lord, on behalf of the electoral body...
Let me summarize it.
Yes, my Lord.
This.
Yes.
Just sit down. During the hearing of the case, almost without exception, every IBC officer who gave testimony asked, did you report? They also said, was this outside the polling station? Did this occur outside the polling station? I gave a long introductory discussion about the powers of IBC because it is important for IBC to remember that during or in connection with anything to do with elections, IBC is the policeman of Kenya. It's not the Kenya police. So that you cannot wring your hands and say it was not reported, we don't have an OB. No complaint was made. You have seminal powers. IBC. You have powers as a commission, even to investigate. You just need to read the newspaper. You hear something occurred, you run. Just like the Kenya Revenue Authority. When they hear ching, ching, ching in your mobile phone, they come running. That is how ABC is supposed to operate under this constitution and the laws. So that is one of the big areas I'll be discussing in the recommendations.
Yes, my Lord.
In India, it is clear that IBC behaved, sorry, not IBC, the Electoral Commission there behaved the way IBC behaves today. They changed. They became proactive. The code of conduct is enforced in India. And in fact, in India, the petitions are very, very few. I was there myself, personally. There are hardly any petitions because IEBC does its work. Yeah.
Well, my Lord, while you're still on that...
Now, this is not part of the judgment.
That's correct, that's correct, my Lord. It's also my observation. And my Lord, the reason why we would wish to have some of these issues clarified would not wish, my Lord, even to disturb that kind of fighting, because, my Lord, this is the first time I have had an election court making such kind of pronouncements in respect on how the IBC is supposed to conduct. So, my Lord, even when you hear us making an appeal, we just want to make sure that we buttress some of those issues that you have said in your judgment.
But you will notice that in discussing the powers of IEBC and its authority, this was not in respect of an issue for determination. So all that is mostly, what you call it, what, obiter?
No, it's not obiter, because you're supposed to pronounce yourself in a manner that the law also speaks. It's not obiter.
All right. Anyway, you will take the judgment to the next court. But what worries me is what I see every day happening, because we are all Kenyans. We see things that occur. We hear when there's an election petition or an election, in any part of the country. It's reported in the newspapers. There are clips from all sorts of places. We don't believe everything. But we are able to get the general mood of people. And that mood, although we cannot represent it in our judgments, it has to come through evidence. Parties have to bring the evidence. Even all this bribery, I've actually seen myself clips of people standing in a line being given money. It's just that nobody takes them to court. But these are things that IEBC has the power to curtail, even under the Constitution. Under the Constitution. And the DPP cannot say that he's the only one who can investigate or prosecute, because the powers have been given under the Constitution through a statute for prosecutorial. So one of the things I'll be proposing is the setting up of an inspectorate of IEBC. That's one of the things I want to recommend. I can't recommend those things here because it wouldn't make sense. But there must be some kind of inspectorate. I don't know how Kenya Revenue or Kenya Anti-Corruption Commission, how they do it. But however they do it, they seem to be fairly effective. That's what we want with IEBC, because the Constitution guarantees us a free and fair election. It guarantees Wamuthende that when she's going to her polling station, nobody is going to sumbua. No masumbuko, I'm going to vote and I'm going to vote for who I like. And if I take your money, I will still vote for who I like. Okay. So that's the key point. Sorry, anything else?
Yeah, my lord, maybe just Obita, as I thank you for the way you have conducted the proceedings and the efficiency, also to bear in mind the timelines which the respondents are really given to respond to this such a bulky election petition, a single 7 days. Some of the irregularities, my lord, which may go unexplained, could be because of this scarcity of time, my lord. Otherwise, it's to say that yes, my lord.
Do you put it in the report?
I did. I did, my lord.
Okay.
Otherwise, we take a lot of lessons as IBC, and we appreciate you a lot and your entire staff. Thank you very much, and even to council who appeared in this matter.
Yes, my lord. For the fourth respondent, we appreciate the pronouncement, except on one issue. I think Mongala has taken the bulk of the cost. Perhaps we'll have a discussion outside the court, if you can share something with us. Otherwise, my lord, we are happy in the manner in which you have conducted this petition. We are also happy with the judgment that you have pronounced today.
Of course you would be.
Yes, naturally. But on my part, I'm most impressed by the time you've taken to give IBC the teeth that it seems to have lost along the way. I think for me that's a very proactive judgment which will clean up the electoral practice in this country. Otherwise, thank you very much from the fourth respondent, and we do congratulate you, but my colleague has something to say. Thank you, my lord.
My lord, we welcome the well-reasoned judgment of this honorable court, which has really shed light on very pertinent issues that arose from the petition, and our client, therefore the respondent who is present, takes this opportunity to extend a hand of friendship to the petitioner, now that the court has decided. And as we are aware, politics and democracy in their very nature are competitive, but it takes a wise soul to accept the electoral and judicial outcome in stride. And I recognize that Mr. Njiro is already in agreement with the position taken by this court, and indeed he says he wishes to go to the Court of Appeal to buttress the decision of this honorable court. So we are of the view that Mr. Njiro may want to take into consideration the will of the people, the constituents of Beere North, who would desire that going forward, the game moves from the court to the ground in terms of development programs, in terms of rendering of services, such that no more attention will be devoted to court proceedings. Therefore, the respondent has had a lot of distraction during the time when these proceedings were in progress. He had to shuttle between the constituency and the court, and that has unduly impacted on his ability to fulfill the promises that he made to his constituents. So we would be glad if this matter can rest at this stage. We continue to celebrate the wisdom of this court together with the petitioner, and it will be good for all of us, because sometimes you win, sometimes you lose, and even then, the next election cycle is just 1 year away, and I'm sure our client, for the respondent, will be willing to make some considerations which would be favorable to the petitioner, depending on how the petition takes the outcome of these proceedings. Now, with regard to the prayer for the costs, we'll also be making an application that the amount deposited as security for deposit be released to the respondents.
Are you doing that application now?
Yes, because
I've already given the stay of 30 days. So
Yes.
even if you make the application,
yes,
it will not affect the stay.
very well. Then the amount can be released to the respondents on the 31st day. That's all, my lord.
Judge, we thank you for the detailed judgment and the way the court has conducted this particular petition. I as a Kariuki Njiri, I'm the senior most for the petitioner, and on behalf of the petitioner, we thank the court for the judgment. At the same time, to remind my colleague, Mr. Kamotho, that the petitioner and the 4 respondents are friends, and they will remain as friends besides their political diversity. One issue, we would like the court to give directions on the electoral materials. My colleague had requested me to mention that, and also the keys that we are holding for the safe room going forward. We shall be inviting Judge Karudhoi to thank the court formally on behalf of our team.
I forgot to say anything about the electoral materials. Obviously, they will be returned, but let that come through a direction that I'll give the DR, which will, so I'm just saying directions on electoral materials will be given to DR to effect. Yes. Thank you for reminding me.
Thank you, my lord. I noticed today the role of the bar saying thank you to the court has been taken up by several people. I think it's what they say, that success tends to have many fathers. But on behalf of the bar, we would like to say thank you for the way the matter has been conducted. On the end of the petitioner, we may not be happy, but we are grateful. We have been handled, managed, treated with utmost professionalism. And I think that no one sitting on this side can take it away from this court. And even next time, if there is, we will be more than happy to end up in this court. And we also hope that all the issues that we picked up for recommendation, that they are going to be acted upon to make the resolution of electoral disputes to be enhanced. And that is why I wonder, looking at the spirit with which we have gone, I was of the thinking that Mr. Kamotho or Dr. Adrian Kamotho should be looking forward to a robust appeal process which will actually even make these issues clearer, instead of offering an olive branch while the petitioner is actually going after the whole tree and its fruits. So we hope that we will be fully facilitated with everything that we have asked for, and we wish the court all the best going forward. And thank you very much.
Thank you very much, Council. I take that with a lot of appreciation. You noticed I started by appreciating and acknowledging you all, because I didn't know what might happen after I make the final determination. And I didn't know whether there is enough security. No, thank you very much, Council. I have also enjoyed myself during this whole exercise. And you say when we do it again. I hope we don't. By then, I think I should be an elder doing an alternative justice system next year. But thank you very much, all. I appreciate you. Have a good afternoon. Oh, I have not used my gavel, and somebody complained. So let me use it today. Let me use my gavel because it has not been seen to be used. The proceedings are closed. May we stand? Thank you very much. You must have you must have
kulingana na sheria. Koti imesema kwamba haikufuata sheria. Ni vile inasema pia tena hakukuwa na ushahidi ulikuwa. Na pia tutafuatilia kuona wale ambao walileta violence, hiyo recommendation ikikuja. Wale ambao walikuwa na alter hizo forms kama vile koti imesema. Wale ambao walikuwa na assist zaidi ya voter mmoja. Hiyo ina include wale mapio wale walikuwa kwa hiyo station wanaruhusu hiyo, na pia wale watu wenyewe walikuwa na assist. Tutafuatilia kuona kwamba haki imetendeka kwa watu wa Mbeere North. Tutafuatilia mpaka ODPP ashike na astaki hao wote, including state officers ambao walikuwa wanapeleka violence ambao wametajwa, kuanzia CS huko, tukisema governor wa hapa na MP. Nakumbuka pale Kaungu kuna mtu ambaye alipigwa risasi na bodyguards wa MP wa Wamuthende. Hiyo tutafuata, lazima ifuatiliwe tuweze kuona haki ya watu na kwa sasa tutinaiganira kira tweka ni twetikania na igoti aria reuga ati nima kwi maundu matekirwo wega. Igoti ni riauga ni kwari na violence Kaungu, ni ritikania ningi ni kwari na violence kuria Itumbiri, na ningi ni riuga kwi maundu IBC itekire kuringana na watho. No rera uga ati ni yathi gutara uguo kona ta wira ucio timiganu kuhagura ithurano, nikio tuga ni tuguthii appeal. Ugirikana igoti nogana na recommend andu kadhaa manyitwo na mathaguo. Naguo niguo turugaga ati githurano kiu gitiarumirire watho, andu IBC gitiakinyirie gikiro kiria kiagirire kurumirira watho, kuona andu ni maraikia kura gutari na violence, gutari na voter bribery ndio yakuga ni hapo ni mwake na igoti voter bribery no ria niona etigo thibutwa na wasi koguo iguru na macio mangi timu itu ni gusaba appeal niguo tuone ithurano gikihabwo
Wakilisha kifupi kwa Kiswahili, hii ni siku kuu kwa demokrasia ya hii nchi. Manake koti imetoa uamuzi na ikadhibitisha yale ambayo tumekuwa tukisema ya kwamba Mheshimiwa Leo Wamuthende alishinda kihalali. The court has affirmed that the election conducted in Mbeere North was free, fair, transparent and credible. Imesema hata kama kulikuwa na mambo hapo, side shows zilikuwa zinafanyika huko nje, uchaguzi mwenyewe ulifanyika kwa njia ya haki, na ikaibuka ya kwamba kulikuwa na mshindi ambaye ni Wamuthende. So tuna furaha mpwito kwa sababu mahakama imetoa uamuzi bila mapendeleo yoyote, na pia huko kotini tumesikia wale ambao ama yule petitioner ambaye alikuwa ameleta ombi kotini amesema amekubaliana na uamuzi wa koti, na hata kama ataenda kukata rufaa, ni rufaa ya kuambia mahakama ya rufaa buttress, hiyo ndio maneno ametumia, itilie msingi hii uamuzi kwa sababu ni uamuzi wa maana. Na pia tunafurahi sana, na sisi unajua kwa timu yetu tuko roho safi sana. Ndio kiongozi wa Mbeere Kaskazini Mheshimiwa Leo Wamuthende amesema ya kwamba anataka kudumisha urafiki na wale watu wote ambao walikuwa na msupport na wale walikuwa na support mlengo wile ingine, kwa sababu sasa anataka eneo lake watu waingie kazini, watu waanze kazi, watu waendelee kutimiza zile ahadi ambazo walitoa. Ndio hali ya kiuchumi, hali ya kimaendeleo ya eneo la Mbeere North iendelee kuimarika zaidi. Kwa hivyo sisi tuko na furaha tunangoja tutoke huko nje. Unajua mheshimiwa ni mungwana, tukishatoka huko nje tutafanya ile celebration ambayo inastahili. Na hii ni ishara, kwa sababu kuna wale walisema ya kwamba uchaguzi wa Mbeere North haukufanyika kwa haki, wakaleta fitina, wakaleta propaganda. Sasa the court imeangalia hayo mambo yote kwa kina, moja kwa moja. Walikuwa wameleta maneno, kulikuwa na maneno ya violence, kulikuwa na maneno ya suppression of voters, kulikuwa na voter bribery, kulikuwa na hayo maneno yote. Court imeangalia, na katika kuangalia imezingatia ya kwamba kulikuwa na scrutiny. Hii ni uchaguzi ambayo imefanyiwa the highest level of scrutiny katika inchi kuliko zile uchaguzi zote zingine ambazo tumeweza kuwa tunasimamia. So kwa sasa mimi ni mwambie congratulations once again Mheshimiwa Leo. Sasa enda ukalia kiti vizuri, hakuna threat yoyote, na uendelee kufanyia watu wa eneo la Mbeere Kaskazini kazi, na tunakutakia kila laheri, na Mungu akubariki, Mungu abariki Mbeere North, Mungu abariki Kenya.
Asante. Ndagitari na ndagike mwetwiri atiri igoti ni rietuga ni undu wa andu aria maragia gikundi twiha kana moya itua ruga
itua riri ni twaria mukira wacha nini sawa
we'll give him time
ataongea
ndio no aria giko na nigira tumona ku tigacoke
so hii leo ni siku kubwa, ni siku kuu. Leo hata hatuna haraka, unaona bado tuko na hizi nguo za kazi. Gikuyu riu Julia
igoti ni riatua na twi haha nja muoya itua riu gati
itua riu ni turemukira na gikeno na nduhio, ni tondu ni itua tuturite twetereire, tondu ria githurano giki giekirwo ni twahotire kuga na makuna ati twahota na njira ya kihoto, na uhotani witu ndaumanite na ungumania, ndaumanite na uici, na noguo igoti riauga ati uhotani witu ati twahotire riua ri iguru gatagati oguo kuhana umuthi, na niguo igoti rietekania na ithue riauga ati uhotani witu ni uhotani mwitikiriku, ni uhotani mukinyariru, na ni wakindiru ni igoti muthenya wa umuthi.
Uko twire na kipere
simama hapa sasa. Simama hapa.
Wakiri igoti ni riatua na ni rona andu ni akenu na muheshimiwa haha, rona andu ni akenu muheshimiwa haha, hihi itua riu mwario yake
kanyambe ni mukethie muriaro thie turita mawakiri ma mundu gwitwa Wamuthende, turi akenu nondu ituru ria goti, nondu ni twathikiriria wega muno, na jaji no acokeria mundu gwitwa Karish macokio make manana maria matigarite, nondu mairi ni twambite tukimathengutia mbere ya cira yambiriria, magitigara manana na ni macokerua rimwe kwa rimwe na monthe magwa. Kwina kaundu kengi jaji ongerere bau ke iguru ria mau ma Karish wanako no wona gatire na gatinge bota kugarura uria andu a Mbeere North matwire, na koguo turi akenu nondu jaji no dismiss petition yo onde ya Karish, na koguo Wamuthende ni we MP wa Mbeere North. Bau vengi no mbugire jaji no ageria kwereithia mavinya maria IBC ivetwe ni gatiba na watho, na maundu maria IBC agirwo gukorwo igika indi ya ithurano. Bau na unga mukono muno na nakena noguo jaji auga, nondu riu IBC ni amenya ati twanginya yeterere borithi mamitwarire report, kana andu maria mara complain matware report kwa borithi, na twanginya meterere borithi ati manyite andu mamatware mena uvoti wa gutwara cira igotire watoria DPP angitwara. Ngwiciria jaji augite no eka wega, andu acio monthe jaji agweta makora mavititie mekire tumavitia hapa na pale, gutire ivitia riekirwe ni Wamuthende wanari rimwe, mavitia mekirwe ni andu mengi, na gutire mundu waretire wira kuga ati no Wamuthende wamutumite eke mavitia marekire. Andu amwe metu ingi supporters ma Wamuthende ni magwetetwo muno na kuringana uria jaji auga no kwandika recommendations matwarwe gotirira criminal. Obviously andu acio metu tukamateterera cira ciaoka tondu nginya wira urutwe uria wagiririte. Koguo aria metu supporters mangikorwa mavutitio ni ndeto ino matikamake matora ciakago tuko hapo kuatetera. Gwicira uguo naguo ni ngiuga no ngana wina kiuria kingi.
Mheshimiwa igoti ni ria gukindira na ni ria guthie na mbere na wira uraigua ta mheshimiwa
wa mbere ni gucokia ngatho kwi mwathani nondu wa maundu maria mekika umuthi ni tondu matirai maundu mavuthu. Wira riria utekaririte giti wega ukimenyaga no kurwete gego wira ni umaga, lakini ni menda kuga gutie muthenya nararire ngionaga ta kwi undu wingi ungithie na mbere ni tondu twi ni twacindire kithurano giki ni nacindire na andu engi ya mbere North makiuga marenda Wamuthende ai munjumbe wao. Koguo ni menda gucokeria Ngai ngatho, njokerie mawakiri makwa, andu onthe ya mbere North aria makoretwe makimboera, andu onthe ya Kenya tutam aria makoretwe makimboera ni macokerie ngatho muno muno muno, na mbuge uria igoti ria tuo munthi ni undu mukinyaniru muno, na jaji uyu nuonekete nurekite research muno tondu no auga kinya kwi maundu ona na ni akwira IBC uri ingika niguo kithurano kiu kingi gakorwa gikiararo. Koguo ni ningienda kuga ni thengiu muno na ni nakena muno mithenya iri ithatu guo ni muturu torora kini umuthi ni ngumama wega takaru kenge. Yes.
mheshimiwa ngira supporters yakwa ala matala
ya ni ngwenda kuga watoria na thurwa na ugire kwi andu manthurire kwi andu matanthura na kinyo munthi andu onthe ni monete maundu maria nireka na usawa gute kuthurukania niguo tuthie na mbere twi kindu kimwe. Kwi andu mai mwena ucio wingi mavenetwe ni mundu wa Mombasa ndigakinya guku ana ndise kimbere ndi registered na magitikia na riu ni marona nira marutira wira. Koguo ningienda kuga gwi supporters akwa muthenya wa muthi ni wa gikeno na nitugukena muno. Gwi supporters aria makoretwe maguciriritwe kuma November magia na meri 5 makimenyaga ati no agucenjie ni menda kumwira pole, lakini undu wa bata ni ati anamwe ni mwacindo munthi ni tondu riu ni mukugia nafasi ya kundoria ta mutongoria niguo mumenye kana mukanthura kana mwikara wa varia murari nundu wa wira uria ndutite kana metwe ni kuruta. Koguo ni ngwenda kuga kinya kwi Newton Karish nie ni nao maundu mama matiai makenana na uguo ringi na ni ngwenda kumwira umuthi anangienda ni mutumire athuri tuonthe twi ya mbere riria turaruire igotiri twi brothers ti undu mwaro na nie ni ready kurutanithia wira na ni ready kinya twathie court of appeal, my team is ready, lakini nundu wa andu wa mbere North anakava tukethanitie niguo mundu evange 2027 gukauka kuria andu wa mbere mamuthure marute Wamuthende ithenya ria gutindaga igotiri tugitera andu etu mathaa na tugitambia nyingi ta icio ciukite kunengerwa Wamuthende. Leo nataka kushukuru sana Mwenyezi Mungu kwa matokeo ya leo kotini. Mimi leo Wamuthende koti imeangalia ushuhuda wote ulioletwa na koti ikaamua kwamba leo Wamuthende alichaguliwa kihalali. Mimi nilishinda hiyo uchaguzi. Mimi sikuwa na shaka. Nilikuwa na mawazo hapa na pale na kukosa usingizi, lakini mimi nilijua Mungu ambaye nimeombewa sana na wa supporters wangu, watu wa Mbeere North, watu wote ambao ni watutam ambao wanajua Sisi kazi yetu ni maendeleo, sio kelele, sio matusi na sio kujipiga kifua. Sisi ambao tunanyenyekea kwa Mungu na tunaomba kura kwa amani, sisi tulishinda vizuri na kwa haki. Mimi nilishinda. Nashukuru sana na niambie watu wa Mbeere North, asanti sana kwa maombi yenu. Timu yangu ya mawakili, asanti kwa kazi mzuri, na Wakenya wote kwa kuniombea. Mimi niseme kiongozi yote sahi amechaguliwa, kazi afanyie wananchi. Mimi nipimwe na kazi yangu, na mimi nasema hata kwa mpinzani wangu ambao nasikia wakisema na kila mtu anajua, na mtu yeyote yako kwa mtandao, enda kwa hizo proceedings za hii case. Kila mtu aliona hapa ilikuwa ni mambo ya mchezo tu. Kwa hivyo kama wanataka kudanganya ndugu yangu twende tena appeal, mimi niko tayari, lakini niko tayari pia tukae chini na wazee na tuseme kwamba 2027 haiko mbali, yeye ajipange na mimi niendelee kufanyia watu kazi, tukutane na kwa debe ya 2027. Hiyo ndio haki. Lakini kama wanataka tuvurutane kotini ni sawa, na mimi natumai nitakuwa nauliza mawakili wangu. Leo nimeongezewa pesa na nilikuwa nimesema hiyo pesa itakuwa ya sherehe na watu wangu. Tukienda huko mbele waende waongezewe ingine wanipatie, ni sawa. Mimi sina shida ya bure, mimi sikatai, lakini mimi najua watu wa Mbeere North ndio watakuwa wanakosa maendeleo, kwa sababu kila saa nitakuwa kotini na naambiwa sasa hata itakuwa mbali. Kwa hivyo mimi nashukuru sana na nashukuru Wakenya wote kwa kuniombea, na niseme nitafanyia watu wa Mbeere North kazi, na watu wote supporters wangu, wale supporters wote wa Karish, nyinyi wote na wahudumia kwa usawa bila mapendeleo, na usinitakie kuanguka, uniombee nifanye kazi ndio watu wote washerehekee. Na hii ndio kitu naona sana online. Na mimi wacha kwanza niseme, kama Kanywambora Irrigation Project tumeangushwa na contractor, nimeteta huko mpaka saa hiyo contract inakuwa terminated na tupewe contract mwingine. Watu wengine wanapiga serikali wakisema inashindwa, lakini contractor ametuangusha. Hata nimesikia ni Muhindi. Nataka watu wa Mbeere, watu wa Embu, watu wa Mlima wa apply hiyo tenda, ndio tupate mtu ambaye atatufanyia kazi akijua sisi ni ndugu zake. Number 2, Gikuyari barabara, watu wa Muminji, hiyo barabara msifurahi ati mkisema haina pesa, haina nini. Nimeipigania sana. Kwa hivyo badala ya kusema maybe haitafanyika ama nini inafanya isifanyike, wacha sisi tusukume serikali, tusukume contractor ambaye ako site, ndio hiyo barabara iwekwe lami, na tuombe lami ya kuongeza mpaka ifike Ishiara. Kwa hivyo mimi nawaomba munipatie nafasi ya kuwafanyia kazi, kwa sababu hiyo ndio jukumu langu, na mimi kuwafanyia kazi ni haki yenu kikatiba. Lakini matusi kila saa na vitisho kila saa, tafadhali mimi naomba heshima sasa. Mnajua mimi si mtu wa matusi ama kelele, mimi niwafanyie kazi. Yani tuteane.
Congratulations.
Yeah. Thank you. Yeah. Yeah.